I'm Eric Sauver with the Law Office of Eric M. Sauver, and today I want to talk to you as a business owner and employer about a very hot topic in the Department of Labor and the IRS. And that topic is the correct and proper classification of your employees and your independent contractors. Now, many of you may have seen this topic in the news and in the media and also been warned, and perhaps you've even had some colleagues who own businesses who have been brought up by the Department of Labor on investigations for misclassifying their employees as independent contractors. Maybe you yourself received a letter from the Department of Labor. So the question becomes, how do you make sure that you're correctly putting your employees in the employee status and your independent contractors in the consultant independent contracting box? Now, the IRS has developed a 20-factor test that has to do with the autonomy, direction, and control that you as an employer or a company have over the worker. The Department of Labor has a similar test, but what I've found with my clients is that I can boil this down to you to 8 key factors that you want to consider to determine whether or not your workers are or should be considered an independent contractor or an employee. Now, I'll start by saying that for employees, you have different obligations as an employer than you have with independent contractors. As an employer, for example, employees are entitled to certain money out of their taxes for unemployment insurance and for FICA and FUCA and other federal and state benefits. You also have to provide employees with workers' compensation, and they're covered by certain anti-discrimination laws. Whereas independent contractors are more like a separate business. They're not entitled to vacation days or sick days. They don't get protected by the same overtime laws and such. So with that in mind, it's crucial that you have your workers correctly classified. So why don't we go through the 8 criteria that I found most helpful. The first thing you want to do is make sure that your worker owns and operates the equipment that they use while working for you. If they're doing, for example, web design and marketing, encourage them to use their own laptops, their own computers, their own devices, their own programs. If a worker is doing some sort of freelance work for you and writing, they should have their own research mechanisms or laptop, once again, or other types of tools and equipment. That seems to imply a level of autonomy, direction, and control in the worker's hands and not so much for you as a company. Another factor to keep in mind is to make sure that the workers pay their own expenses if they're going to be an independent contractor. Now, this rule, this criteria has some exceptions, of course. For example, if you're doing a video photo shoot for a company and your photographer would have to spend more money on airfare and travel than the shoot would pay, well, then you can certainly pay for those expenses. But for the most part, things like traveling to and from your place of work or traveling to a client should really make sure that the worker is paying their own expenses. Another factor that you want to look at to see whether or not your worker is an independent contractor or an employee is to look and see if they're paid by the project or paid by the hour. Now, not all work is project-based, but if you have somebody who's designing a website for you or some marketing, and you can classify this as a project basis, it would be beneficial to pay the person as a project-based worker. You also want to be mindful of the hours they work. I've seen companies, for example, that have workers who are working so many hours a week that in theory they're told that you're free to work elsewhere, but if they're working 9 to 6, 5 days a week, they're sort of a de facto employee, right? Because you are, as the employer, limiting whom and where they're able to work. Which brings me to another point. You want to make sure that your independent contractors know that they are completely free to work for the competition, free to work for themselves, and free to have their own clientele. Now, you can have an independent contractor sign a non-solicitation clause, which essentially prevents them from taking your clients or your prospective clients. But you do not want to have a non-compete. If you ask an independent contractor to sign a non-compete agreement, that means to ask them to sign something that says they cannot work for the competition, then you are exercising a certain level of autonomy and control over that worker as such to render them an employee. Another thing you want to take a look at, and all of these factors, by the way, keep in mind the three basics, right? You want to make sure that the independent contractors are folks who have autonomy, direction, and control over their financial arrangement, their schedule and their behavior, and the way in which they're hired, behavioral, financial, and directional control. So you want to make sure, for example, that to the extent possible, an independent contractor is permitted to make their own schedule. Now, you may have certain ranges if your company is open from 9 to 6 and somebody's a night owl wants to work from 1 in the morning to 7, that might not cut it. But if you have someone that can be working for your company and there's the opportunity for flexibility in their schedule, then you should make it clear that they're allowed to have that flexibility. I would also encourage workers where possible to work off-site if they can in fact do the work from afar, either by telecommuting or another basis. But you can have workers work on premises. You can call an independent contractor for a meeting or for a half day at your office. But it's just important to note that where the worker works from, the location, the schedule, the hours, all of those factors are considered to determine whether or not your worker is an independent contractor or an employee. Another factor you want to take a look at is making sure that you are not minimizing or controlling your independent contractor's dress or appearance. Now, again, this factor alone is not determinative, and there can be situations where you have a certain type of dress code in the office that you want to present to clients and customers. But try to stay away from having independent contractors and freelancers wearing, for example, company uniforms, company logos on their jackets, and so forth. All of these factors, including payment, are very crucial as well. I always recommend to my clients if you have 3 employees and 1 independent contractor, that you don't pay everyone on every single Friday or bi-weekly for that matter. You want to encourage your independent contractors to have monthly invoices, and you like to make sure you pay them usually on a monthly basis. A week-to-week check starts to look like a paycheck, and that starts to look like an employee situation. Now, when you have all these factors in place, it's really crucial that you memorialize them in writing in a contract between you as the company and the worker as the independent contractor. By doing this, you not only make sure that you have a record of how you're treating your workers, but you also make sure that they're not going to go to the Department of Labor one day if they're ever terminated or let go and claim that none of these criteria were in place. If you follow these criteria both in practice and in contractor agreement, you have a much better chance of demonstrating to a court or the Department of Labor or the IRS that your workers are correctly classified, either as consultants or employees. I'm Eric Sauver from Law Office Eric M. Sauver. For more informational videos on employment law and labor law, please click and subscribe to my YouTube channel. And thank you for watching.